Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer. Good morning. Today we're going to be talking about the Department of Labor's new rule regarding independent contractors. Everything you need to know as efficiently as possible. Good morning, Rebecca.
Good morning, Sarah. We're going to do this.
We are going to do this. And I am grateful because between the two of us, you are the one that knows the most about this rule. So thank you, first of all, for
Yes.
taking that on and for having the knowledge and information. I know I have received a lot of emails from different sources. I've gotten client questions about this Department of Labor rule. And I also need to understand, what the heck is this rule and what does it really do? Can you help us, please?
When we hear about a new federal rule being issued, it sends a little bit of anxiety through all of us, right? Certainly as lawyers, but as HR folks too. We all had a million other things to do that day.
Right.
And then there's this breaking news, and we think, is this something I need to drop everything else for or
Yes.
not?
Okay.
Right? And so, spoiler alert, I think this is not something that needs to shake
good.
up your organizations right now.
Excellent.
So let me explain why that is.
Okay.
So for a long, long time, the Department of Labor had a certain test for whether a worker was an independent contractor or an employee.
Okay.
Okay, it was a totality of the circumstances.
Rebecca, just to take a step back, why does that matter? Why does it matter if somebody's an employee or independent contractor?
Well, that's a great question.
For the Department of Labor's
Yes, and of course,
specifically.
the Department of Labor is not the only
Right.
agency or organization our clients need to worry about. We'll talk about that
Right.
a little bit later.
Okay.
But under the Department of Labor's umbrella, you have overtime and minimum wage.
Oh, I see. So if somebody's an employee, you have to pay them minimum wage and overtime. But if somebody's an independent contractor, that organization may not be doing that, correct?
Right. Oftentimes, independent contractors are paid project-based.
Sure.
And they often don't record
I
their
see.
hours.
Right. Okay.
So if it turns out a year or two or three down the road that the Department of Labor determines that your independent contractor was really your employee, now we've got to figure out how many hours they were working.
Right.
And again,
right. Sort of like misclassifying
always
somebody as
60 a week.
exempt. Yeah, sort of like misclassifying
Yes,
somebody as exempt
it's
when
just
they should
like
be
that.
non-exempt. Okay,
you got to
got it.
figure out how much they were working every week. It's always exaggerated after the fact. You have no way to disprove it.
Got it.
Right? And also minimum wage could be an issue.
Okay.
If they say they worked 60 hours in a project, but you paid them
I
$50,
see.
you might have minimum wage obligations too.
I see.
So that's where the
Okay.
Department of Labor comes in. And if they do find there's back wages owed, either minimum wage or overtime, it's the back wages, and then they're automatically doubled. That's called liquidated damages. So automatically doubled.
Okay.
And then if it's a lawyer instead of the Department of Labor, that's coming after you on behalf of the plaintiff or the employee, independent contractor, they also get their fees. So if this is not a one-off, if this is a whole group
I see.
of folks
Okay.
who were allegedly misclassified, the dollars can add up pretty quick.
I see. So
and that's
that
just
part of
Department
it
of
matters.
Labor.
Okay, so that part of it matters.
Yes.
And then I interrupted, but you started to talk about this test, whatever the Department of Labor is doing now, and why it's maybe not such an emergency.
Right. And of course, we like to cause anxiety
Yeah.
sometimes, right? When people really need to change what they're doing, we like to be the first ones out there saying, everybody stop what you're doing, stop your
Sure.
handbook project, stop everything else, and look at this. But in my opinion, this
Right.
is not one of those circumstances. So let's look at what the Department of Labor was doing before 2021.
Okay.
They had this totality of the circumstances test, and no one factor weighed more heavily than any other factor.
Oh, how helpful.
I know, right? That's literally what keeps us in business.
That's right.
These sorts of tests, no bright lines. And the factors they looked at was the amount of skill required for the work, whether the work was integral or the most important thing that business did,
Okay, sure.
whether the workers invested in their own equipment, tools, and supplies, whether they bought it themselves, and the degree of the permanency of the relationship.
Okay.
Right? How long was this contractor actually doing this work
Right.
for you? And a subset of that was exclusivity. Were they doing work for anyone else, or are they only working for you for
Makes
an
sense.
extended period of time? So this was the DOL's test. If anyone, and many people have talked to me about this over the years, these are the factors we would often discuss. In 2021, the DOL changed the rule. They changed the test.
Okay.
So in 2021, there was this new rule, and it said two factors were going to be most important: who had control over the work that the worker was doing, and opportunity for profit and loss. Who had that? Did the quote-unquote contractor have it or not? This test was widely viewed as making it much easier to classify workers as independent contractors.
Okay.
Right? So in these, there's certain workers where they're obviously independent contractors, right?
Sure.
If you hire a painter we here at Miller Johnson hired a painter, right, to paint our offices. Clearly an independent contractor
Right.
relationship. There are folks who are clearly employees, and then there's this gray area, right? So that test in 2021 for the gray area shifted it towards independent contractors.
Okay.
This new rule just takes us back to where we were.
Oh, before
Right.
20. So
It revokes.
So if our listeners didn't know about the 2021 change, they can really not worry about this change because they didn't know the change happened.
Correct. If you've been
got it.
hibernating on this, keep at it, right? So or what's old is new again, or however you want to say it. No, I do lots of legal update presentations for various groups. I didn't make a big deal in 2021 over the rule, and that the same reason I'm not saying everyone stop what you're doing, right,
Okay.
and turn your businesses upside down over this change. Because let me tell you why. The Department of Labor test is just one test among many, right? You can't just focus on the Department of Labor test. It's an important one.
Well, that was going to be my next question, right? Because
Yeah.
there's the IRS's test, that
Sure.
matters.
Lots of employment taxes, right? That
Right.
makes a big difference in tax liability for you and the worker.
Yep.
If they're an independent contractor or
Sure.
an employee. What about workers' compensation?
Yeah, unemployment benefits,
Unem-
FMLA, whether somebody's an employee or independent. And so all of those tests are also different than this particular test for which the Department of Labor just issued a new rule. Am
They're
I tracking
all
this
different
correctly?
tests just to make
Okay.
life complicated
Yeah.
for businesses. They often come down to a few key factors. Mostly, frankly, the DOL kind of captures it: control over work, permanency of relationship,
Okay.
all of those sorts of things. But the fact that the DOL in 2021 said we're going to tip the scales a little bit in favor of finding independent contractor
Okay.
status over employee status probably didn't change the landscape for most folks.
Right.
For folks that have workers in that gray area, maybe they were willing to take a little more risk and keep them classified as independent contractors because they knew
Right.
the Department of Labor was going to be more likely to find them as independent contractors, and there was a question mark as to
Okay.
what the IRS and others might do. So maybe when they were doing their risk analysis, right, they were
That was
willing to
one
take a
thing
little
they
more
thought
risk
about.
and say, okay, I think we have a legitimate basis to believe
Okay.
these are independent contractors. With the change in the rule, maybe that risk analysis swings back a little, right, and say maybe we don't want to take the risk because now we know if the Department of Labor comes in, they're more motivated, let's just face it, they're more motivated to find folks are employees as opposed to independent contractors.
Yeah, so when you talk about a scale, maybe in 2021, there was a thumb on one side of the scale, and
Yes.
what you would tell clients is that's no longer the case, it appears. And maybe even the thumb is on the other side of the scale now.
Yes.
More in favor of the Department of Labor finding that individuals are employees rather than independent contractors.
And this is also a good example of how election results can impact the way that agencies
View things.
view the law, interpret the law, are going to enforce the law. And we don't think employers should change, right, every time there's a new administration that comes in, switch whole categories of people from employee to independent contractor or vice
'Cause it can swing
versa.
back and
As,
forth,
as
of
we've
course.
seen, this is a classic example. Whether it's an actual change in a rule or maybe just an enforcement priority or interpretation as agencies are going out to enforce. So
Okay.
we always recommend, we look at all the factors, the most important factors that are common amongst all the tests, make the best decision possible. And when an agency comes out and says, which is really what this rule is, we're going to weigh it a little more heavily on this side than on that
Sure.
side. everyone take a deep breath and say whatever decision we made before is probably still going to be okay.
Right.
If businesses are talking about this, I mean, this is certainly in the news. I always recommend taking a look at your gray area folks, right? Not because there's a change of the rule, but just because.
It's a good opportunity to think about it.
It's good risk management.
And to bring it up, right?
It's just
a
good risk
trigger for,
management.
let's make sure we're aligned with our organizational's risk tolerance, right? And business strategies, make sure that we're classifying our independent contractors or employees accordingly.
Yep.
Okay, that makes sense. Okay, so one more question for you. What if an organization looks at this change and realizes that with the thumb on the scale, now where it is, they have individuals who they think they're uncomfortable classifying as independent contractors,
Yep.
okay? There's a lot of wringing of hands over that.
Yes.
What's your opinion on
A lot
that?
of pushback from the business units, right? When HR suggests
Yes.
that an independent contractor should be an employee.
Right.
Let's face it, right? And so for our listeners who are part of the HR community, they're all nodding their heads right now.
Right.
Because
Yeah.
Their stomachs might flip and say, you don't
So
actually
how-
expect me
right.
to go tell someone that their independent contractor should actually be an employee. But we found when we actually bring HR and the business folks together, and we talk about the whys, we drill down a little bit
Yep.
and say, why is it important to the business that this be an independent contractor instead of an employee? Then we find we can often meet the business's needs through a traditional employment
Oh,
relationship.
interesting.
I mean, there's certainly going to be
Interesting.
additional taxes. We're not magicians here.
Sure, it
right?
doesn't solve the tax problem.
We can't solve that problem, but we can solve problems like the two big ones that come up, I find, variability in hours,
Yeah.
and then the permanency
I was
of the
going to say it's
relationship.
the permanency of the relationship.
Those
I
are the-
hear a lot.
Those are the two big reasons I hear a lot. So let's talk about permanency of the relationship
Okay.
first. So someone might say, the business might say, I don't know how long I'm going to need this person or this role filled or this group of people. We have maybe one large order, right? And I don't know if another large order is coming in right after that or whatever the case may be.
Boy, that sounds like at-will employment to me, Rebecca.
It does,
Right?
doesn't it?
And good communication at the front end. I mean, wouldn't
It's a
you just say to that
combination.
person, we need to be honest, this may not be a long-term role, right? We can
Correct.
expect to need you for 6 months, and we'll have to reevaluate as to whether we need you beyond that. I mean, you could get to the same place by just telling an employee that from the outset.
Highly recommend that open communication. You're right. And if your employees are at will, and most are, right? Of course, we're not talking about union environments. But for at will employment relationships,
Right.
You can
That's
end a
true anyway.
employment relationship for any reason or no reason, so long as it's not an unlawful reason. The problems arise, the risk level arise when a termination is perceived as unfair for any number of reasons. That's when you and I tend to get involved. But if the person is told at the outset, right, this is based on a certain client
Right.
project, this is based on a certain upswing in demand, whatever it is, now you've taken away that perceived unfairness when that time period passes. And you say, oh, guess what? Actually, that we didn't get the next large
Right.
order, so we are going to be reducing.
And I think the exact same thing could be said of the scheduling
Absolutely.
issue that you mentioned, and I assume you mean, I don't know how frequently not just how long, but how frequently or when I'm going to need this person to work. We can handle that at the front end. So that's very helpful and good information for folks to have. So.
It is. It's very, very common for folks not to come into a conversation assuming that's true. I'm not sure exactly why that is. But I've talked to many people over the years who do not think that can be part of a traditional employment relationship, where some weeks there might be 0 hours. Right? And then the next week 2 or 60 or whatever it is, and then the next week 0. They assume that has to be an independent contractor relationship, but it's really not true.
Well, thank you for your help and information on that. I know this has been very insightful for me as well. I appreciate it.
You're welcome. We got folks in and out, right?
We
promised
did.
to be efficient and just what you absolutely need to know.
That's exactly right.
Before folks start
In
their
less
day
than
today.
15 minutes.
Did we do it?
We did. Yes. Excellent.